good evening, depending on you tuning in, and just me and my special guest for very first legal round. Joining me need no introduction. They are super lawyers. But I will quickly distinguish panel of Robert Liles, Ronald Chapman. Liles is one of the founding members of DC, is one of the group, and Colin, are you a partner with Flannery Gregalis? He is. So I will make sure that I put into the session description a link to each of these fine gentlemen's law firms and to their profiles at their firms. Again, thank you, gentlemen, for being here. I know we're going to have a great conversation today. We have 3, maybe even 4 topics that we're going to try to hit over the next 30 to 45 minutes. And we'll see where it takes us. So again, Robert, Ronald, Colin, good morning, gentlemen.
Good morning.
Morning.
Good morning.
All right. So I want to begin, if I can, by talking about the proposed rule change. And this appears to be something that could be pretty significant, and it should be raising a lot of concerns for folks out there. Robert, so the proposed change is 0.305, which for everyone is the 60-day rule. And what we're seeing is a definitional change being proposed specifically to the term knowingly. So let me stop there, because you're the legal expert on this, and I want to get your take on really what CMS is doing from an administrative standpoint in tying it to the criminal law.
It's a little cryptic. Let me give you just a little bit of background. In mid-December, CMS issued a fairly extensive set of regulations covering Medicare Part D. Almost all of it was Medicare Part D, but they had a few things sprinkled in there on A, B, and C. And one of the issues that they sprinkled in there was just literally a paragraph. And I'm going to hold it up. I know you can't see it, but this just kind of shows you this is all it was. Okay. Very little talking about how this proposed rule that was in this document, it was 950 pages or so. I think it was published in the Federal Register on December 27th. But the proposed rule included a provision there that essentially said, we're going to change what it means to identify an overpayment. And we're going to revert back to what we proposed in 2012, which is a knowledge standard using the same knowledge requirements under the False Claims Act. I'm not necessarily opposed to that. I don't think anybody is, because I think that most of the attorneys, and I'm sure the folks on this call, that's how we always kind of viewed it anyway. The problem is, though, that when they said this is the current language under A2, and it includes language such as, the exercise of reasonable diligence and the ability to, the clock starts once you quantify the extent of the problem. And they took all that out. They stripped it all out and just left it as you've identified an overpayment if you have knowledge that the overpayment exists, which is actual knowledge, reckless disregard, or deliberate ignorance. And Sean, you're a certified coder. I'm a lawyer, but I'm a certified coder. And you and I both know we run across problems, despite the fact that CMS works very hard to give guidance. I truly believe that, in the form of LCDs and regulations and MLMs and all the rest of it. There are a lot of things that they don't have answers to. And sometimes you and I run across problems that not only can we not tell the magnitude of the problem and the overpayment, but we're not even sure if it is an overpayment. And now they're saying that if you have reckless disregard or deliberate ignorance, in other words, if you run across a problem and you know it's a problem, and an overpayment, you've got 60 days to return it. Well, that's almost impossible from a practical standpoint. So I'm not sure that CMS really kind of thought this through. And despite the fact that there's a lot of folks out there that think that they've thrown out the quantitative requirement, and there's questions about the 6 months and the rest of it, I don't know that that's necessarily the case. I think we're gonna have to wait and see what they come back and say.
Well, and to your point, we're in an open comment period right now. And, I can't stress this enough to the public who are listening. You have got to comment on these things.
Yes.
Because again, for me, I'm one of the people that looks at it and says, if you've stripped out the terms reasonable diligence, what does that actually mean? Does that mean that we no longer have the 8 months to conduct a bona fide investigation so that when we go to make a voluntary refund, that we have had an opportunity not only to identify a potential overpayment, but that we've had the ability to confirm it and to follow the structure of the guidelines that are provided for us to do a look back within the period that is required and then to quantify that overpayment? Because the way it's written, and Colin, I'll come to you next, the way that it's written, it basically says, once you've identified an overpayment in the proposed rule, you have 60 days in which to issue your refund.
Mm-hmm. Yeah, it's just not a practical way to approach these issues at the end of the day. I liked when Robert kind of put up the actual paragraph, right? Because, if you were going to do this, burying it essentially in something where the headline about what they're actually doing here ostensibly has nothing to do with the actual implications of it certainly isn't the right way to do it. I was glad to see, Sean and others kind of publicizing this change, earlier, when you originally posted on it, Sean, because, it is important that sort of folks out in the bar, in the community that deal with these kinds of cases are aware of it and do get those comments in. I'm guardedly optimistic that we can get this turned around and that this isn't sort of what's actually going to be implemented. But, in my practice, where I do, both criminal defense work and then also a fair bit of False Claims Act defense work, this would just be a nightmare, right? I mean, it's just not hard to build up a set of facts where you need the kind of time that was permitted to go through an orderly and good faith process, to identify exactly, what is problematic out there, the exact contours of it, and then to quantify it. And, in my days as an AUSA, because I originally did, mostly ACE stuff before I flipped over to the criminal side, if you're going to come forward, let's say you're going to do a self-disclosure, for example, well, you have to have that quantified number anyway, right? I mean, that's literally a piece of it. If you decide that you need sort of a False Claims Act sort of self-disclosure going on here, as opposed to just sort of a, pure overpayment issue. So just the current approach shouldn't have been buried the way that it was. It's good that there is, sort of the growing awareness. Hopefully we get it turned around, because otherwise it's going to create myriad problems that, frankly, I don't even think prosecutors in the U.S. attorney's offices want to deal with themselves.
Yeah. Hey, Colin, I'd like to ask you a follow-up. I mean, wouldn't you agree, though? I mean, we were all AUSAs at some point. Yeah. Wouldn't you agree? I don't know of any AUSA who is, remember, CMS, they can say this all they want, but they don't have independent litigation authority under the False Claims Act, right? So any of these cases that would go forward, they'd have to go to the U.S. Attorney's Office. And any AUSA that looks at this is going to say, wait a minute, you didn't give them an opportunity to even figure out the magnitude of the problem?
Right. Yeah, I agree with you. And, I certainly like to think most folks are reasonable in that way. They're not looking to kind of create problems. On the other hand, I think the scenario that I sort of can certainly imagine is perhaps you and your client are in agreement that there are some problems that need to sort of go to the let's say the U.S. Attorney's Office. There's disagreement, as there often is, about the scope of those issues, or maybe, I agree as a defense lawyer, you're right about one of these things and you're wrong about three of them. And then you get into that more adversarial sort of back and forth with the office. And then all of a sudden, sometimes all bets are off in terms of, actually, this is a reverse False Claims Act case as well. So that's what I worry about, at least.
That's a great point. And, so Ron, I wanted to come to you still on this topic, right? Because again, I know Colin, Robert, you all engage in building compliance programs for your clients, right? Hospitals, health systems, physician practices. Ron, the same for you through your consultancy, through Chapman Consulting Group. One of the questions that I have is, what do you do? I know we're still in a proposed rule making, period, but how would you suggest writing a policy on voluntary refunds if the language, for whatever reason, goes into the final rule as it's proposed right now? What would you recommend to clients? And then I want to get further analysis from you on, the proposed rule change.
The first issue that I have, it's again another government is going to screw over the little guy. Mid-sized entities don't have the program available to them. Some of these issues actually quantifying about, and then bring it to the federal government and take care of the overpay. To see this rule is going to be turned into a weapon. The federal prosecutors there and saying they had this program, and they didn't take care of the problem, gives them 60 days in order to, I see it being weaponized. It might be a benefit to some, but hurting them.
It seems to be a solution where there's no problem. I don't know why they're messing with it. I mean, some people say it's because of some litigation out there where, involving the advantage plans and the rest of it, where they say that CMS exceeded their rulemaking authority, but if that's the case, go through the proper comment and rulemaking process and fix it. Don't mess with the rule that's working fine.
So there's two additional thoughts, and I think you started to touch on these, but I wanted to ask the opinion of the panel. One, why would CMS align its definition with the criminal component of the False Claims Act, 31 USC 1349, right? And the definition of knowingly? That's the first question that I have. And the second is, do you believe that it is intentional to be ambiguous on the definitions tied to the terms reckless disregard or deliberate ignorance? I'll open it up, Colin or Robert or Ron.
I mean, I can jump in, just offer my 2 cents. I think the commentary I've seen, the ostensible reason for this, in addition to what Robert already kind of mentioned, was this idea that the current standard could create liability on a pure negligence theory, right? So it's being presented as if, hey, if your providers or physician groups out there, whatever the case may be, don't worry, we're helping you, right? This is actually being presented as helpful. It's like, well, thanks so much, guys. That's wonderful news. It doesn't. I mean, I was in government for a long time, right? 7 years. It's mostly good people trying to do good things, even when they're wrong sometimes, in my experience. And I also think the government is generally not going to be competent enough to actually come up with a broad conspiracy theory to actually screw people. Usually, anyway. So I don't necessarily think this is intentional. My guess is that this is somebody trying to solve a very specific, small potential problem, and in so doing, creating just a whole new cascading set of problems. And so that's partially why I am cautiously optimistic that as people like Sean, sort of publicize these things and industry groups come in and weigh in, that this is going to get sorted out. In terms of tying it, to the False Claims Act standard, and I know this is going to be kind of one of our other topics here, it's obviously fascinating to sort of do that tying in when the Supreme Court has just sort of agreed to take 2 consolidated cases about what knowingly actually means for purposes of the False Claims Act. And so, there's certainly a degree of irony there that, hey, we're going to clarify all this by linking it to a term that the Supreme Court is now going to clarify how it actually operates, which, I was certainly amused by.
Yeah.
Well,
Ron, please.
I much more pessimistic view government. In my experience, the government tried to in its statutes and regulations to allow prosecutors to have to say they want to go without having to fix mens rea. We see this happen. We're also seeing it happen now. And one of the issues I have in this definition to the same thing, prosecutor or a civil AUSA identical standards, and they're which way they want to go with this case. Statutes were meant to do. They were supposed to be.
Yeah, guys, I think we're having some audio difficulties with. We want to hear everything that he's saying, and we'll come back. We another topic that I think is indicated that he's going to be rejoining us here in just a moment. All right. I want to move to you started to bring up, Colin, looking at what's referred to as the Scienter standard. And could you explain to our listeners?
Yeah, and I mean, just as a general rule, right? I mean, the entire idea of what the mindset that somebody has to have in order to be guilty of, a criminal offense, or a affirmative from an affirmative fraud perspective, civil context, a crime. It's not sufficient, and it should never be sufficient under sort of our legal system and sort of the pillars that it's built from to simply make a mistake, right? And for all of us that exist in the healthcare space in particular, where the rules and regulations and guidances are so complex, that's even more important than it might be in other areas of criminal law or affirmative civil enforcement sort of matters. And so that's the Latin word Scienter sort of applies there, and it really means what is the mindset that you have to have, what is the knowledge level that you have to have in order to be found criminally culpable or culpable for affirmative civil enforcement purposes under the False Claims Act here. And so in most False Claims Act cases, depending upon sort of how they're held, interestingly, knowingly never has really meant knowingly, right? And so instead, the False Claims Act defines that as acting either with actual knowledge, deliberate ignorance, or reckless disregard. Those are sort of the three typical prongs through which the knowingly requirement can be satisfied in the False Claims Act context. And although we generally think of the False Claims Act as sort of a civil vehicle, it's mostly what the billions and billions of dollars of recoveries that the government sort of puts together every year kind of come from. You're right in what you said earlier, Sean, which is that it can also be a criminal statute here. And so in these consolidated cases, I'll just tee it up, and then Robert, Ron, you guys can maybe lead with the analysis. But we've got two consolidated cases that are going up in front of the Supreme Court right now, the super value case and the Safeway case, that the court is due to sort of weigh in on sort of how this operates within a particular context where there are reasonable and sort of dueling interpretations, let's say, of a particular requirement that are reasonable on their face. And you've got different circuits that have come to different conclusions thus far, creating a circuit split as to whether or not the proper focus is sort of just ipso facto, if there were multiple reasonable interpretations available, versus then that's a defense from a Scienter perspective and something isn't knowing, versus whether or not you have to get into the subjective understanding intent of the defendants or the targets at the time that the purported false claim was sort of submitted. And so I'll pause there and kind of let others kind of talk about it, but just at a broad 10,000 foot level, that's what the court's looking at.
I'm glad you were able to rejoin us. And why don't you pick it up from there?
Yeah, absolutely. First, I want to make sure y'all are hearing me okay. You got me loud and clear? Okay, great. Sorry about the issues there. Well, the way that Colin just teed it up actually, I mean, makes it sound like the False Claims Act version of Ruan, really. And I think the Supreme Court is poised with the conservative majority that it has right now, but mostly a limited government majority, to start taking a look at a lot of these definitions, things that Scalia probably would have wanted to do a while ago, and see if we can tailor some of the statutory support for these allegations. And I think, if I really had to put a prediction on it, I think that the Supreme Court is probably going to say that you're going to look at the subjective component. They thought that way under the Controlled Substance Act cases, which we're going to look at later. And it seems to be that's the trend of the court. They want to make sure that before you really get into these issues, that people know. One of the things that you and I talk about a lot, Sean, and I think we maybe wanted to do this in a trial someday, is to pull just about every single piece of sub-regulatory guidance we could and bring it into a courtroom in front of a jury and say knowingly means, according to the government, you had to know every page in these books, when you're talking about false certification. And so I think that, the Supreme Court likely recognizes that it's impossible. And so you need to look at some subjective intent. Now, the question that I would have for all of you is whether or not the Supreme Court is going to still look at this deliberate ignorance issue the way the government has traditionally fashioned it, and say that deliberate ignorance means you had a duty because you signed an 855 to know the rules and you didn't follow them. I've heard prosecutors say that before in court. I think it's inherently flawed, but I'm just wondering if you think the Supreme Court may tackle that issue too.
Yeah, I think it's a great question. I mean, in some ways, it's almost the more important question, I think on a practical level. And, there's a circuit split on that teed up as well. And so it wouldn't surprise me if that works its way into the final opinion here. Frankly, I don't know how you tackle the issue that's clearly been accepted for cert without also getting into that Sixth Circuit versus Eighth Circuit split on the duty to inquire, kind of, I think, as they put it.
Yeah.
Robert, I don't know what your thoughts are. I'd be curious to hear.
No, I agree with you completely. I'm looking forward to hearing the decision.
So, Ron, if we can, I want to go back. Yeah, Ron, if we can, I want to go back to what we were talking about right before we ran into the audio difficulty that we had. We're starting to talk about the mens rea in the prior topic that we were talking about with the proposed change to the language.
Yeah, I'm used to having a court reporter read something back to me, Sean. I don't remember what I said 5 minutes ago, but let me try my best. I think what I mentioned was I have a little bit more pessimistic view of government than maybe Colin does. And this is just probably coming from two different camps here. The way that I see it, we see this constant pull by the courts to blur the line between the criminal components, knowledge components, scienter components, and the civil. And one of the reasons I believe that the government traditionally does this is because the government tends to think with an expansive view, and the prosecutors who are likely driving these cases want to be able to select where they hit their target. And they want to do it based on unenumerated factors, which I see, as a bit of an issue. We have all on this panel seen cases where they could go either way, where they could be prosecuted criminally or civilly based on where the case originated and what AUSA got it and who made the referral. I think that that's a bit of a problem, because if we see these scienter requirements as being inherently the same, even though legally we think they're supposed to be different, prosecutors think they're the same, then you're putting all of this in the hands of the government on their decision to prosecute. I think it creates tremendous vagueness issues. I also think that in these matters, the tie should go to the runner and civil enforcement should be chosen. But it's creating a bit of a problem in the healthcare space. We've got a lot of regulations, a lot of people who don't know all of them, and intent is really the important factor, and we're getting no guidance from the court on these issues.
Yeah, and just for what it's worth,
I think
Ron, you and I completely agree with the danger of all those things. So we're very much in the same camp in terms of the practical applications. And I think, just to even amplify it a little bit further, it really is it has to be the court's job to do that work, right? Because the reality is, I don't always think even the aggressive prosecutor it has a ill intent when they are acting in a way that I think is inappropriate, as I often do, right? But I don't necessarily blame them for not being able to control themselves. That's why we have different branches of government, right? And the court needs to step in and actually create and enforce. I know that last part's important. Enforce more black letter law that provides sufficient notice to everybody as to where those guardrails are. So I think what you said was very well said. That's all of our kind of jobs, is to make sure through that adversarial system that prosecutors are going to seek to expand what they can do. They're going to seek to expand their own discretion. That's time immemorial. Prosecutors have been doing that. Hell, I was probably guilty of it when I was a prosecutor.
Oh yeah.
I like to think that I was less bad than some. But it's the nature of the beast. And so all of us, and hopefully with the court kind of on board, need to make sure that we constrain that government power.
I think we all were. And let me just jump in, Sean, and add one additional point. I agree with Colin.
Go ahead.
One of the issues that we've had in this area is the cabining of universal health, Escobar, to just the FCA arena, when we see prosecutors also offering this false certification theory in fraud prosecutions, but we don't get the same benefit of materiality, the definition of materiality, in the criminal arena, because no circuit court, and certainly not the Supreme Court, has ever gone so far as to apply the two. I found this tale in a Sixth Circuit case that got us close. Unfortunately, a judge in Tennessee rejected me last year on that. But that's what we really need. We need the definition of materiality to ring true in the criminal arena when they try to bring these false certification cases.
Robert, I want to ask you a question, and I'm sure you probably have some thoughts on what the gentlemen were saying. Thinking back to your time, where all of the AUSAs in the country reported to you, what kind of guidance were you providing when it came to making these kind of determinations as to whether handling something from an administrative standpoint, declining the case, referring it back to CMS, versus looking at it from a civil versus moving into a criminal? And the reason why I ask, I think we all know Jose Villa Jr.
Sure.
He's a former prosecutor down in the Southern District of Texas. Good friend, great guy, knew him when he was a prosecutor. And one of the things that he shared with me was that 85% of all of the cases that they had that came in as civil turned into a criminal investigation.
Wow.
But I wanted to go back because I want people hearing from, and this is why I asked for you all to be my first panel. I mean, you can't get higher, into the prosecutorial world than what you have sitting on this panel right now. So, Robert, with all taking that into consideration, how do you look at when you were over all of the AUSAs versus where things are right now, and sort of how it's gone differently?
Well, I wasn't over the AUSAs. I was the National Healthcare Fraud Coordinator for all the U.S. Attorney's offices. Of course, the AUSAs. The AUSAs reported to their presidentially appointed U.S. attorney. But so much has changed since then. I mean, when I was there, to answer your question, I wrote drafted the first guidance on use of the False Claims Act in civil healthcare fraud cases. And that guidance is still around somewhere, but it's been, overshadowed now by all the subsequent guidance that has occurred. But I would also say, we're talking about, so much has happened since then with the passage of the Affordable Care Act, and they made it such that a criminal anti-kickback case can also be pursued as a civil False Claims Act case. Ron talked about guardrails. Well, it's almost impossible to find these guardrails as far as I'm concerned these days. If you talk about the kickback statute alone, there's now more than 30 statutory and regulatory safe harbors for the anti-kickback statute, and nobody really understands how all of them work. And they sure don't understand the personal services safe harbor. They don't understand the employment safe harbor. And they think that they're entering into bona fide employment agreements with people that in fact end up being a violation of the anti-kickback statute. And that going back to what Ron said again, these AUSAs have an extraordinary amount of latitude when deciding what to prosecute and how to prosecute it. In a case that I think should be pursued as a civil False Claims Act case that I handled recently in South Texas, the government chose to pursue it as a criminal anti-kickback case, despite the fact that the damages were almost zero. And, much more serious cases around the country were being pursued by other AUSAs under the False Claims Act. So I just wish that there was some way to kind of rein in some of these outlier cases, because these prosecutors, and I understand they're doing their job, and in their view, maybe that's the appropriate way to go. But it's just really hard to give guidance to our clients these days, because we can't really tell them it's going to stay civil. It's very possible that this case is going to be referred to the criminal side of the house. And of course, the current DOJ policy is that when something comes in, both sides are supposed to be looking at it on the healthcare side.
Yeah, right.
Yep.
Well, and they certainly do, right?
Yeah, and they do.
Yeah.
Yeah.
I think we're probably going to talk about
this was a great. Yeah.
Sorry.
Go ahead, Colin, please.
Just to code
Go
up,
ahead.
what can I say? It's an interesting topic, but the other thing that I would just add, you've got significant variability, not just prosecutor to prosecutor, not just office to office, from a U.S. attorney's office perspective. But I think that the strike forces also add kind of another, layer to all of this. Depending upon which of sort of those operating entities, I'm dealing with, it's a completely different calculus in my head as to whether or not you've got a shot even to convince somebody that something's a civil case. And, I won't go into detail about, I think everybody in the area can kind of probably do the math in terms of where you have the better shot. But, that it creates a very challenging environment for, people to actually go about the business of healthcare, where the regulations themselves and the guidance that's out there is insufficient, and where it's not just sort of discretion within, DOJ as an entity, but it's really very different cleavages within DOJ. So.
Ron, I want to go back to you, because John, I think, posted a really good question, and you were talking about the mens rea. And his question is, without a clearly defined mens rea in healthcare, don't we end up leading to the criminalization of medical decision-making for providers? And I wanted to go to you because you and I have had the conversation about over-criminalization quite a bit lately.
Well, yeah. So first, that is very fancy, putting the question up there. That's amazing. I love it. And John out there, great question. My answer is we're already there. We've already criminalized medical decision-making. We already have, as you saw during the Bothra case, Sean, and to some extent during the Pompey case, the government saying you can only get a certain number of injections. That's all we're going to allow. That's not really based on valid medical information. And if you violate that LCD, you can face criminal prosecution. Providers limit their treatment based on regulations. If they fall outside of that, it can be criminal. The way that this should be is that providers treat the way they want to treat. They bill for what they believe is reasonable and necessary, and the insurance companies, including Medicare and Medicaid, can elect to not cover it. We don't just look retrospectively and immediately call that healthcare fraud. So I don't want to give a doomsday scenario here. I think we have a path forward. And I think that comes from exactly what we're talking about during this discussion, narrowing the Scienter requirements and ensuring that before somebody can be subjected to civil or criminal liability, they actually intended to defraud a healthcare program.
That's such a great answer. All right, Robert, Colin, anything more to add to saying?
No, I think that's right. And, I guess maybe the only addition is just, it's both criminalization, but I think you've also got, federalism concerns when you're talking about, federal criminal law. There's a flavor, and I know we're going to talk about Ruan in a decision in a second here, but there's at least a flavor to me that you've also got sort of federal regulations and the federal government sort of usurping some power that traditionally should be kind of in the hands of state government that are best positioned to sort of figure out how to regulate, the healthcare space and, the way that doctors, for example, go about and make decisions. So over criminalization generally, I'm with you. But I think there's also, over federalization of some of these issues as well.
Yeah, notice as Ron was talking about violation of LC, reminded me of a case for a pain management physician, specifically in line with what Ron was talking about, where his clients were criminally charged, but we wound up having what turned into a strict liability situation. And what was mind-boggling to me was the attorney at OSIG basically saying, I don't care about medical, about generally accepted standards of medical practice.
Yeah.
You can do 4 in a rolling 12 months, and anything beyond that is a violation.
Yep.
How is that?
Yep.
How is that good medicine? How is that not practicing medicine without a license? I don't get it.
Well, depending on the case, sometimes I'm happy if they say they don't want to look at medical necessity. Okay. But in this particular case, we felt very comfortable with medical necessity. And in fact, we also felt that, based on medical necessity, we think that there can be deviations from the LCD. And although it may only permit 4, in this case, this patient got 5, and here's why. And we were also able to show in that case that other LCDs didn't have those limitations. And the government still came back and said, no, we don't care. And if you, in fact, don't settle this case, we're going to impose CMPs, and it's possible we could even seek exclusion. So, when you have the sword of Damocles over your head and it's still administrative and it's not going under the False Claims Act and it's not being referred, sometimes you have to talk to your client and say, this is not the battle to fight. And that's really the case that you and I worked on, Sean. But once again, that's a case where it's just not right, in my opinion, when they can show that it was medically appropriate to do more than the specified minimum number or maximum number, and other parts of the country, there is no maximum. I still have a real problem with that case.
And let me also mention, the question is, where was Alina? Oh, sorry, Sean. My issue is, where was Alina on all of this, right? We have this wonderful case that came out that said that these unpromulgated guidance documents shouldn't be used. We have a jury instruction that is generally given in most circuits that says violation of regulations alone are not healthcare fraud. But then we also have prosecutors standing up and saying, yes, it's not alone evidence, but here's an LCD and you broke it. And now the burden is on you to prove your medical necessity as to why you did that. It's an incredible burden shift.
Well, Ron, in this particular case, we were knee deep in Alina, and we were pointing out every one of these arguments, and they still said, we disagree.
Yep. Well, that's it.
And what was amazing in this case that we the fact, and he agreed with us that there was pointed out the OIG study from 2014 that is leading to a tremendous problem, proper processing and adjudication of claims, and the practice actually received a letter from Medicare or Medicaid services that said, like for you to you said, oh no, you're not getting away with that. We want our double damages because we found the problem. Right, Robert?
Yeah, it's just very sad.
Yeah.
And I was really disappointed, frankly, because most of the time when I deal with OIG,
Yeah.
For the most part, I think they're pretty straight. But this, and it wasn't the attorney on this case. This was one of their projects, and they had already set aside. These are the parameters of what we're going to permit, not going to permit, and if you don't like it, you can take it through the appeals process.
Right. All right. I want to address the impact of, at least in my opinion, I feel Ruan has played so that were tried in federal court, and what it is doing and forcing prosecutors discretion before bringing the Ron. I know you have had an exorbitant amount of experience in these Substance Control Act cases. So I want to come to you first, and I want to give you an opportunity to talk about Ruan and where you think it's going to play in the future.
Sure, Sean. So as many may know, I was very involved in the Ruan case. I represented Dr. Couch, who was Ruan's co-defendant in front of the Supreme Court, as well as Dr. Naum, who received a GVR in front of the Supreme Court as a result of Ruan, and then was involved with an amicus brief in Ruan. So we know the issues well. I will tell you, when the cert grant came across for Ruan, my first thought was they granted the wrong case and the wrong question. And I don't think that they knew it. The question that the court initially essentially certified was a good faith question, whether or not physicians get the benefit of good faith. But we have so many other problems with the Controlled Substances Act that could correct what's going on. Looking at good faith was very strange to a lot of us in the community, right? In fact, the first issue that we all have is the conjunctive disjunctive view of 841 and what outside the course of professional practice and legitimate medical purpose actually means. Exactly. And despite the fact that Ruan went through the courts, there is no clearer definition of that language in the statute that was provided by the Supreme Court. This case has got to go back up because it's unclear. So just to set the table on Ruan, the Supreme Court determined that physicians must subjectively intend to violate the Controlled Substances Act and prescribe without authorization. The court stopped short, though, of saying whether that subjective intent must relate to a standard of practice generally recognized in the community, and that's where the jury instructions fights have been post-Ruan. Judges who want to use Ruan as a weapon against defendants are saying, okay, we'll give you subjective intent, but that subjective intent relates to a standard of practice generally recognized in the community. Well, that's not really saving doctors very much, because what that means is if you subjectively intended to violate a malpractice standard, so to speak, you can be guilty of criminal conduct. And that's not what 841 was ever meant to criminalize in the first place. It's an incorrect interpretation. In the two cases that you were talking about, Sean, that I tried, both received full acquittals in front of Judge Murphy in the Eastern District of Michigan on each and every count. But Judge Murphy's instructions were not very defense friendly. All due respect to him, the circuits hadn't addressed the Ruan decision, which was sent back. So he was operating flying blind, essentially. But they were not friendly instructions. So to get back to the essential question, what is the impact of Ruan? It's left a lot more questions than answers. It's causing more circuit splits. It's causing more bizarre jury instructions to come out, and everybody is confused with how to handle this case. Both Ruan, Naum, and Khan, those three cases are likely to petition for cert again, because in the Ruan remand case, the 11th Circuit still convicted Ruan of conspiracy, despite the fact that they said the 841 instruction wasn't good. I'm going long here, and I apologize. But these cases have to go back to the court. And just like any big movement in the court, we see cases a couple of times. It took the court a few times before Brown v. Board actually, was clear guidance. So we look forward to that.
Colin, I know you've had your hands in a few substance. Well, thoughts. Where have you seen your cases going, and what are your thoughts or impact that Ruan has on these cases?
Yeah, I mean, I certainly agree with Ron that I think there's still unanswered stuff out there. But one thing that I've certainly noticed, and this is kind of across jurisdictions, at least so far, I think the government has been knocked back on their heels a little bit in terms of, what they do with cases where even if there is still uncertainty about some things there, I think there is a pretty good awareness on the DOJ side of things that the old playbook doesn't work anymore. Mm-hmm. It's no longer sufficient to do the kinds of investigations that they did before and use the same experts that they've been using for years now and have that expert stand up and basically give a medical malpractice opinion, in my view, and where that's just definitively going to be enough in most cases to leverage a plea or to actually win a conviction. And so, I've certainly had cases that were active investigations when the decision came down that are no longer active investigations. So that's a positive to me, where at least some prosecutors in some jurisdictions, I think, have been educated on sort of the nature of these cases. Obviously, there's going to be other ones where I think the folks on this podcast right now would think, the obvious implication of Ruan is that those cases should also go away, where the government will press forward, right? And that's where I think the clarity that Ron's talking about is going to come. It's going to take some fairly courageous, clients out there, though, to sort of have the gumption to actually go through, what is a horrible, harrowing process to actually get to and live through, a federal jury trial where, not just your livelihood, but your liberty is at stake. And that's unfortunate, to say the least. But I have seen some changes already. When I go in to make a declination presentation to a U.S. Attorney's office right now on one of these investigations, I think we all have, additional arrows in the quiver as a result of the decision that are very, very helpful. I'm hopeful that at least maybe some of the worst abuses are already starting to sort of roll back, but there's more work to be done.
Yeah, I would just like to add,
Robert, go ahead.
Yeah, I think Colin hit one of the points right on the head, and that is, prior to Ruan, I mean, one of the complaints that we've all had is in most circuits, they wouldn't allow you to really go in and issue jury instructions saying that this is, being a bad doctor is not a criminal violation of the Controlled Substances Act, and even if he's not a bad doctor, there are certain patients that, for whatever reason of their metabolism or they've been on these opioids for a long time, you would have to, in fact, to vary your prescribing practices to a degree that someone may consider those to be irregular and outside the standard of care. That, once again, that's not a criminal violation of the Controlled Substances Act, and they just took it too far. And I don't like them criminalizing medical malpractice or these obscure cases that are out there that doctors are really just trying to help the patients.
Yeah. One sort of related point that I would just throw out there, it's a little bit of a hobby horse for me, but actually two, because Sean, you've heard all this stuff before, but the CDC guidance that is changing here at the same time is absolutely crucial to all of this. And, I think that has been as big of a kick to the nuts for the government as anything, frankly. So, I think the two together have been really powerful. That's a Latin phrase there, kick to the nuts, for anybody who doesn't know. Yeah. And then, the other thing here that just drives me crazy, I mean, it generally in criminal practice, but maybe even more in this context, the way that the government has at times used relevant conduct in these prescribing cases is just, it's not right. And there's a growing movement to sort of address that, hopefully to get that up to the Supreme Court as well. But where you see 100 scripts for 3 patients, and that's the subject of your jury trial, your indictment, And then when it rolls around to relevant conduct, the government sort of says, oh, by the way, there's 10 more patients. And if you don't plead, that's all going to come in at sentencing. And your guy's going to do a bajillion years and die in jail. That just can't be the way that the system operates, right? And, including, by the way, acquitted conduct, right? So, we can literally be sort of the subject for sentencing purposes. So, that all needs to be addressed here as well, generally, but it's a particular problem here.
And just one last thing, Sean. Everybody seems to, the government just ignores the fact that this is really having an adverse impact on patients that actually suffer from pain. I mean, it's getting harder and harder for pain patients to find a doctor who is willing to actually treat them and give them the opioids that they need to deal with cancer and other types of illness. It really, John Yuki earlier talked about the criminalization of healthcare. This is a criminalization of pain. It doesn't pay to be a pain doc or a pain doc these days, because no matter what you do, you're going to be on somebody's radar.
It's extremely unfortunate. I don't remember what the pod had a surgical, right, and with 3 pills, abdominal surgery, whatever the heck was going on. Now, fortunately, I don't take oxycodone or stuff like that. I feel like I to try to, and ask whatever, but I'm a person there who their receptors are and don't same way. And there are people to your fighting terminal illness, individuals who have issues that they are not make the pain that they're feeling. And I've said it a number of times, and I'll say it again. If you want to deal with the real epidemic in this country, start at our southern border. That's where the real epidemic on the opiates is coming from. It's not sending an agent into a practice, exaggerating problems and saying, you got to give me Oxycontin, and and putting these physicians into these horrible entrapped situations. So, Ron, I'll go around the horn real quick. Let's get a last word from each of you gentlemen.
Last word. Let me jump on my soapbox, or back on my soapbox. I have to say, the reason why we're having this problem in the United States is because of the burden shift of big data. In the healthcare context, the healthcare fraud context, and also the opiate space, we have the government trying to create regulations that will allow them to look at this data from 30,000 feet and figure out who the wrongdoers are, right? So we have that happening. They issue the CDC guidelines, which talk about risk and opiate limitations and sort of hard values and MMEs for cutoff. We have LCDs that come out that give you strict numbers of the amount of procedures that you're allowed to do. And then we have them combing through data using things like Palantir, dare I say that word, to go through and find out who the wrongdoers are. And then we see investigations not in order to determine the intent of a provider, but we see them to confirm what the government already knows based on its big data and blindly pushing forward. We need to get back in this country into a situation where we feel comfortable that because we've given a physician their license, because we've allowed a practice to open, that they should get the benefit of the doubt of knowing what they're doing. And unless we can prove that they are abandoning that and defrauding the government, we don't go after them. And that's why we need to stop this inherent burden shift that's going on. That's the last word I've got for you, Sean.
Well said. Colin, let me come to you.
Yeah, I think a component of getting to sort of that world that Ron just mentioned, I actually think is probably encouraging more active medical boards and more active licensing boards, by the way.
Yes.
Too often in my practice, those folks are waiting to see what the criminal folks are going to do before they're going to take an action, right? And the real answer in many instances, look, I represent lots of fantastic people, licensed medical professionals that have done nothing wrong. But But I also periodically, represent folks who, look, they stubbed their toe. They did mess something up because they're human beings. I spilled coffee down the front of my shirt yesterday. That wasn't a great day for me either, right? Fortunately, not a licensing issue. But the point is, nobody's perfect, and mistakes, problems, even if real, can be addressed well short of there being criminal enforcement and action, well short of there being affirmative civil enforcement actions, right? Sometimes, one quick example, right? I represented, a number of rural doctors who weren't predominantly pain doctors, who were trying to help their community, and they got into some complex cases that, frankly, they probably weren't well situated to deal with, and they tried their best, all right? In that circumstance, educating that person is the right way to go in terms of helping future patients, putting resources sort of in place in that kind of a context as appropriate, looking at action on licenses. And if we do more of that, you can both address real societal problems and put things on a better path without just coming down with this criminal hammer that really doesn't make sense.
Yeah. Well said.
Well said. Very well said. Robert, let me come to you for the final word.
Well, it's an interesting time that we live in. We didn't really get a chance to talk about all the administrative cases out there and how they feed into the civil and criminal side. But that's what we're seeing a lot of at our firm. And almost all of it is driven, of course, by data mining. And now, of course, the big word these days, everybody's talking about Chat GPT and AI and the rest of it. We are going to see more and more cases pop up and be referred to DOJ by the UPICs and possibly by the RACs that are based almost entirely on data mining. And it's a problem that I've been in healthcare for a long time, since 1984. And I remember in 1984 or 1985, the government came out with this project called A76. And A76, the purpose of it was to try to contract out as many programs as possible to the private sector. Seemed like a great idea. I think that it's gone off the rails when it comes to the UPIC programs and the RAC programs. I would much rather have a government person doing these audits rather than a for-profit organization who, even if they're not paid a percentage directly, indirectly, that's how they make their money, by finding fault. And when you have someone that's how they make their money, everything, of course, looks like it's wrong. And when you're a UPIC, your job is to identify fraud. And that we're seeing them make referrals to the U.S. Attorney's Office and to OIG. It leads, of course, to CIDs and False Claims Act investigations and criminal investigations. I just think that we've got to just stop for a second and look at the system we have in place and see, is this really fair the way we're dealing with these providers?
Yes. Absolutely.
All right. Well, that's going to bring us to the end of our very first installment of the Legal Roundtable. I couldn't have thought of three better people to kick this first panel off than Robert Liles of Liles Parker, Colin Callahan of Flannery Gurgalis, and Ronald Chapman II of Chapman Law Group. Gentlemen, thank you so much for being on the program today. I can't wait to have you back on in a couple of weeks.
It's a pleasure. Thank you.
Thank you so much, Sean.
Thank you, Sean.
All right. And to each and every single one of you who's tuned in, logged on, and hung out with us for this past hour, thank you so much. We'll be back on Monday with our All-Star Coding and Compliance Roundtable. Terry Fletcher and I will be back on Tuesday with our hashtag Terry Tuesday. Jordan Johnson and I will be back on Wednesday with J Squared, the business of medicine and the intersection of compliance. And next week, we'll be announcing a very, very special guest that you are not going to want to miss on this program. So until then, remember, be good to yourself, but more importantly, y'all be good to each other. Have a blessed weekend.